Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? The United States Supreme Court's recent decision to end the Chevron doctrine in the Loper Bright case exposed a governmental fault line, which may have far-reaching implications for many entrenched U.S. federal agency regulations that have existed for decades, and consequently for employers. In this fifth episode of our podcast series, Workplace Law After Loper, we focus on how the Loper Bright case may make it difficult for OSHA's enforcement authority in court. Our hosts today are Melanie Paul, principal and co-leader of the Workplace Safety and Health Group, and Jeremy Fisher, of counsel and member of the group. Prior to joining Jackson Lewis, both Melanie and Jeremy worked for over a decade at the Solicitor's Office of the United States Department of Labor. They now help employers proactively monitor and ensure compliance with all applicable safety and health laws. Melanie and Jeremy, what impact does the recent U.S. Supreme Court decision in Loper Bright have on how OSHA crafts its rules, and how does that impact my business?
Hi, I'm Melanie Paul. I am a principal in the Atlanta office of Jackson Lewis, and I also lead the National Workplace Safety and Health Practice Group at the firm. Joining me today on microphone is Jeremy Fisher, who is of counsel in the Atlanta office of Jackson Lewis as well. And Jeremy and I happen to go way back a number of years because we both worked together at the U.S. Department of Labor in the office of the solicitor in the Southeast. And we were colleagues there for about 10 years. And then Jeremy joined the firm within the last year, and he has hit the ground running. So welcome, Jeremy.
Thank you. Happy to be here.
So today's topic that we are going to be talking about is something that's been on everyone's mind a lot lately. Obviously, the Supreme Court in its last term was extremely active, and in a way that was certainly more positive for employers, and in terms of executive agency authority. So, of course, I'm referencing the monumental Loper Bright case, which overturned Chevron deference, which was deference that was given to agency interpretations of their statutes when they were ambiguous. So now that decision has basically said that courts can handle issues of statutory ambiguity just fine, that they are the experts of those types of questions, and that the agencies themselves don't have special expertise when it comes to statutory ambiguity. And therefore, the court overturned, what has been 4 decades of precedent in this area. That decision came out originally the Chevron decision came out in 1984. So what do you think the future is going to be for OSHA Enforcement Authority and their ability to promulgate standards, or how they interpret the OSHA Act itself?
Well, I think that's a great and complex question that I'm sure OSHA is asking itself right this moment. As you mentioned, the Loper Bright decision so incredibly kind of reversed this 4-decade-long pattern of agencies saying we should have the right to interpret any ambiguity in our own regulations because we're the agency enforcing them. We're the experts. Loper Bright has cut that down, citing Marbury v. Madison for the prospect that courts are the only bodies that can interpret what the law actually says. So right now, what we've seen over the past couple of months since Loper Bright came out was a halt in OSHA issuing what they call interpretation letters. And these are letters in response to employers who write into the agency and essentially ask for guidance on what certain regulations say, how to comply. Under this administration, OSHA was issuing those letters at the rate of about twice a month, and none have come out since early June when Loper Bright was actually issued. And I don't know we're going to see another one of those letters out for quite a while. Loper Bright is going to have enormous impacts on not just OSHA, but every administrative agency out there. Every executive branch administrative agency is affected by it one way or another. So I think while the future is very uncertain, I think what we're probably going to see is more case law, more suits being filed, going up through the system, going through the circuit courts, and eventually going to the Supreme Court to determine exactly what kind of ability OSHA has to not only interpret their own regulations, but to enforce them.
Right. And just when we're talking about Chevron deference and we're talking about statutory ambiguities, but with that, there are, regulations that OSHA promulgates that they have authority to do so under the OSHA Act. But they have to make sure now that the regulations that they want to promulgate follow the Administrative Procedures Act, and also that they have the authority to issue certain regulations under the statute itself. And so that's what I think has been called into question. And, there was another Supreme Court case that came out this term, the Corner Post case, where an employer had challenged the statute of limitations, that 6 years that companies have to challenge a new rule when it's promulgated. And in that case, the employer, the business wasn't even formed until after the expiration of that initial 6 years after the rule was promulgated. And the Supreme Court basically said that now businesses, the statute of limitations for when they can challenge a rule promulgated by an executive agency, including by OSHA, is going to not begin to run until that business has been aggrieved by it. So that's really interesting as well, because that kind of goes along with Loper Bright. It does remain to be seen how that's going to affect the regulatory landscape, but there may very well be businesses that have more recently formed that want to take on challenging rules that have been in effect and enforced and litigated for years.
Right. And speaking of a couple of the sort of the newer things that OSHA has attempted to do, how do you think Loper Bright's going to affect, say, the challenges right now to the walk-around rule, the new heat stress guidance that has come out? How do you see that playing out?
So, of course, on the walk-around rule, there's already been a challenge filed in federal court in Texas. That's been ongoing. And, what's interesting about that, even before the Loper Bright decision, the challenge has been the criticism of that rule has really been, this is not really tied to safety and health, which is the purpose of the OSHA Act and ensuring a safe and healthful working environment for, workers in this country. And so it doesn't really have that tie to safety and health, and seems to be more of a backdoor for the agency to really promote its unionization efforts or pro-union philosophies that have permeated this administration. But, how is that going to play out? I think there's going to be a lot of challenges to the heat rule regardless of Loper Bright, based on the fact that, is this something that an employer can really have control over? And so if you want to relate that back to Loper Bright and arguments that could be made there, if a hazard is not something that is either strictly occupational because of the work environment, or it, in the case of heat illness, there's so many other factors at play, people's personal medical issues, any medications they're on, their personal diets and lifestyle, consumption of alcohol and caffeinated drinks. And, if they've ever had heat stress before, you could be more susceptible to that again in the future. And so these are all things that an employer is going to be hard pressed to control in the work environment. And I think we're going to see challenges, on lots of different, with lots of different arguments. And I think that, Loper Bright can certainly form some of the basis for a challenge to a heat rule in the future. My question to you, Jeremy, is, are the OSHRC decisions self-enforcing, or does a party have to bring a petition to enforce in an Article 3 court?
Well, OSHRC has always had a self-enforcement mechanism because OSHRC actually was created as part of the Occupational Safety and Health Act in 1970. So there is a congressionally passed basis for the existence of OSHRC, and its decisions are self-executing unless they're appealed. What I think is going to be interesting, and we don't exactly know how this is going to play out, but in Loper Bright, the court cited back to Marbury v. Madison for the concept that only courts can interpret the law. And Marbury v. Madison is pretty clearly talking about Article 3 courts, which OSHRC is not an Article 3 court. OSHRC is an executive branch agency. Yes, the commissioners on OSHRC are appointed. However, the ALJs, administrative law judges, are simply federal employees who, up until a few years ago, became ALJs by simply applying for open positions. They are not presidential appointees. They simply have to go through the same sort of interview and clearance process that any other federal employee has to do. So I think right now the real question is going to be, what kind of deference are Article 3 courts going to be giving OSHRC decisions? The standard tends to be arbitrary and capricious, which is a really high standard. It's very difficult to have OSHRC decisions overturned in circuit courts. However, now that we're looking at the way courts are going to be looking at OSHRC decisions, are they going to be giving deference to the commission, or are they going to be giving any deference to OSHA's interpretations that might be echoed by the commission? There's a little bit of a separation there as to what exactly those courts are going to start looking at. But I think that the bottom line is it might take a few years again for these cases kind of move through the system. But I think that employers' chances of having an OSHRC decision overturned before a circuit court is going to be much greater than it has been traditionally.
That's really interesting that you mentioned that. So yes, OSHRC, the Occupational Safety and Health Review Commission, which hears contests of OSHA citations, is a quasi-judicial, quasi-administrative body. But you're right, it's an executive agency where it's supposed to have 3 commissioners that are appointed they're nominated by the president and obviously confirmed by the Senate. And so they're not Article 3 judges. And you're right, the Circuit Courts of Appeals, which in the OSH Act can actually hear any petitions for review from a final order of the commission. And that arbitrary and capricious standard is really very high and difficult for employers to overcome on appeal. And so this could change the whole landscape. And I've been thinking about this, and some of the case law evolved before Chevron, prior to 1984. A lot of the OSHRC case law evolved in its early days, in the first decade of the Act's existence. But one of the things I've been thinking about is the word repeated. So repeated is in the OSH Act, but it's not defined. And that would be a really good example of an ambiguity in the statute, right? But it has been defined over the years by OSHRC and then the courts of appeal. But one would have to go back to all those legal decisions and see if those courts have really been deferential to OSHRC in how it interpreted the term repeat. That's in the statute itself. And this could be a really good area for challenge for employers, because I know I counsel employers all the time that, that's a huge area of vulnerability for them. If you're a big company that has a nationwide footprint, that has multiple locations, different parts of the countries, and the facilities might not even do the same things or have the same type of equipment. But, and I'm kind of talking about a manufacturing type setting because, they're extremely vulnerable, that industry. You could have a lockout tagout issue on a piece of equipment in New Jersey. And then, 4 years later, you have a facility in Colorado and you have a different kind of a lockout tagout issue on a totally different piece of equipment that doesn't even do the same thing. And maybe there was an employee injury, but it occurred in an entirely different way from the previous New Jersey incident. And you can have scenarios that are very factually dissimilar. But basically the case law now just simply says, well, if the hazard's the same, then too bad, so sad, employer. So I think that that's an area that should be examined further by the defense bar, and to figure out what can really be done to help companies try to overcome decades of executive branch overreach of authority, if you will.
Yeah, I think that's a great point. And I think that, one of the other things I've been wondering about, and it's not, strictly a Loper Bright issue, but I would think if I'm a general contractor, I'm pretty happy with the decision and how things are going, because one thing I've been curious about is the multi-employer worksite policy, which is a policy that OSHA developed essentially to allow the agency to cite. It essentially means citing general contractors, but what it allows them to do, or permits them to do, is to cite employers whose own employees were not exposed to a violation, with the logic that, well, they're an exposing employer because they have allowed exposure by other employees. It's essentially a way to cite general contractors for the actions of subcontractors. It's not statutory whatsoever. It's simply a policy. Now, it has been approved and sanctioned by OSHRC, but to my knowledge, I don't know that a circuit court has necessarily blessed the MEP, which is something that employers have really hated since it was established in 1999. So it's another one of those issues that I'm wondering how much the fallout is going to affect the MEP.
Seems like the agency has a lot to be considering. And, obviously this is an election year as well. So that just adds a little spice to the mix, if you will. What's going to happen? And obviously what happens during an election year will have fallout in the following year. Are we going to have another 4 years of a Democratic administration where, we could see continued attempts by the administration to push the envelope, if you will, as is usually done during Democratic administrations. The thought being that, OSHA and of course the Department of Labor itself is really there to ensure, safe and healthful working conditions, and that everybody in the country who's here working has appropriate workplace conditions. And so, with that in mind, agencies like OSHA are always really trying to push to provide the greatest amount of protection possible. So, obviously, if a Republican administration takes over the White House, we're likely to see, less regulation, there'll be more pullback, I think, of a lot of this interpretation and guidance that has come out, more recently, and more of an adherence to the Loper Bright decision.
Absolutely. And I think it'll allow a lot more consistency in terms of guidance, because as you know, and I know, since we spent a long time with the Department of Labor, when administration change, often agencies' interpretations of their own statute changes. So it will be very interesting to see what happens in November and how that affects things going forward.
Well, Jeremy, that was a lot to unpack in a very short amount of time. So thank you for joining me in this conversation today. We're going to continue the dialogue as new issues arise and the agency continues down their rulemaking path as they continue to put forth a very ambitious regulatory agenda. With a number of rules slated to come out later this year. We'll see if that happens. Again, it's an election year, so it's anybody's guess. But until the next time with our podcast, thank you so much for joining us. And as always, if you need any assistance in the workplace safety and health area, please feel free to reach out to Jeremy or myself. Thanks so much.
Thank you for joining us on We Get Work. Please tune in to our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.